If the USPTO feels that your trademark merely describes what your product or service does or is about, you might receive a descriptiveness refusal. Louise's brand Super Sharp might be seen as an example of a mark that would be refused because the name only describes what the product is. Or Frank's brand Hot and Golden as the name of a restaurant that sells pizza, which is descriptive of what most people would consider all pizza to be, not just Frank's. Or Tape and Glue for a shop that sells, well, if a descriptiveness refusal is issued, all may not be lost, as there are 3 possible ways to overcome it. Patty has received a 2E rejection, and she feels that her mark is not merely descriptive, but it is suggestive of the goods or services that she is providing. So a lawyer helps Patty organize her argument into a response. The line between descriptive and suggestive is key. For example, sugar and spice could mean a lot of things at once. Maybe it reminds you of baked goods like cakes and cookies, or actual sugars and spices, or the children's nursery rhyme. But if Patty can show that her mark has acquired distinctiveness or gained secondary meaning in the marketplace, it would demonstrate to the examining attorney that the mark is better understood to indicate Patty as the source of the goods or services than the common merely descriptive meaning of the term. So when consumers hear sugar and spice for a baking company, they associate that with the brand of goods and services that come from Patty. It can take some time and effort for a descriptive mark to acquire distinctiveness. Generally, you need to be able to demonstrate 5 years of use of your mark, or significant amounts of money spent in advertising and marketing, or large numbers of hits or followers if it has been less than 5 years. And finally, if you don't have this long-term usage, promotional expenditures, or followers to overcome this type of rejection, there is still something you can possibly do, which is moving your application to the Supplemental Register. Be aware that only marks that are being used in commerce can be amended to the Supplemental Register. Trademarks can last forever if used correctly. It can be complicated, however, so you may want to consult with a trademark lawyer who can explain the options in more detail and what the possible ramifications are for your mark.